drafting is writing. All right. The idea is that the language of the body of the contract is limited and stylized, but it's still a kind of writing. And so there's some general principles of writing that apply to contracts. Some of them aren't complicated. Like, instead of one long sentence, how about making it into 3 sentences? I turn this into one sentence, this into the second sentence, and then the rest into the third sentence, because 3 shorter sentences are a lot easier to read. I'll skip that, and we'll go to buried verbs. Buried verbs is a way of referring to the tendency of people to use abstract nouns instead of verbs. Abstract nouns are words you can't see, hear, smell, touch, or taste. Nouns that you can't see, hear, smell, touch, or taste. Bottle is a tangible noun, but I just use the word tendency. Tendency is an abstract noun. Hunger is an abstract noun. Administration, abstract nouns. Yeah, you need to use abstract nouns, but the more you use them, the more your prose is going to sound like it was written by a bureaucrat. It's going to be wordy, and also you're going to have a chance to play that favorite game of drafters called Hide the Actor. This is from an employment agreement, the definition of good reason for an employee to quit. The assignment to employee of. Who's doing the assigning? I don't know, because we use the abstract noun assignment. I would say the company assigns. Here, at least we know it's by the company, but still, a reduction by the company sounds bureaucratic. I'd say the company reduces, the company amends, the company fails. Acme may request the withdrawal of. Who's doing the withdrawing? I don't know. We use the abstract noun withdrawal. If you use the verb, you have to say who the actor is. Abstract nouns bad, verbs good. Following receipt.
Excuse me.
Yes.
Yes, I have a quick question.
Sure.
The second example, can we say Acme may request just the council to withdraw without using that?
Well, thing is, it's not the consultant. It's not the consultant that's withdrawing. They're withdrawing the consultant representative. So the consultant has a representative, and so it's the representative that is being withdrawn.
Okay, Acme may request the consultant to withdraw any.
Well, that's what it says, isn't it? Acme requests that the consultant withdraw any consultant representative. What is your suggestion?
Request that the consultant withdraw.
So what would you like it to say?
I request the consultant to withdraw.
Request the consultant to withdraw? Is that what you're suggesting? It's not ideal English, just as a matter of English. It may request the consultant to withdraw. You don't request someone to give. I asked him to give. May ask. You don't request to. You can ask to. So it's just a matter of English usage. It's annoying. English is annoying. So you could use ask, but not request if you wanted to do that. But it wouldn't change the meaning. Following receipt. Who's doing the receiving? If you use the verb receive, you have to make it clear that Acme is receiving. This is useful for any kind of writing, because in any kind of writing, a lot of abstract nouns is bad. I've nagged my poor daughter from when she was small. She's now in college. Don't use abstract nouns. So, of course, she never shows me anything she writes anymore. In fact, now she takes revenge on me by spotting my abstract nouns and laughing at me. Yeah.
For the second example, acne may, any time after, can't we just say any time after it receives?
Oh, sure. I mean, hey, we could maybe spend an entire day on let's clean up Adams's examples.
Okay.
Well, thing, yeah, it's fine. Sometimes you have to be careful about using pronouns because it can be unclear. Who is it? Oh, we were talking about the company and the supplier, and so
That's true.
So,
especially in a long text.
yes, and I think I added to the 4th edition, or if you search for the word pronoun on my blog, I think you'll find a thrilling English case about what the heck does the pronoun refer to. So be careful with pronouns. Just wordy phrases we've already encountered, pursuant to, stuff that only lawyers use. Don't use them. For the 4th edition, I have a list that's 3 times as long, but I keep finding new and different ones, like following the conclusion of. Give me one word you could use instead. Well, hey, the different possibilities there. After. It's following the conclusion. I'm following the conclusion of breakfast. How about after breakfast? Redundancy. Let's just a general look at redundancy. The simplest thing you can do about redundancy is when you can say, oh, we're using 2 or 3 words. We can get rid of all of them except one. So instead of performs and complies with, how about just complies with? Books, instead of books and records, well, financial books of accounting are a kind of record. So let's just say records. That's easy enough. But things are often not that easy. In a contract I had to redraft, I encountered this. Except that the employee may transfer the employee's rights to the employee's personal or legal representatives, blah, 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 devisees and legatees. Personal or legal confused me, but devisees, distributees, legatees, I still have no idea what those are. Just because I know I couldn't be bothered to look them up either, because anyone who reads this is going to say, what's going on? What's the idea? If you have some issue in mind, just express it conceptually. Instead of a list of things like this, what are you trying to say? Here's what I came up with. By will or intestate succession. Intestate means you don't have a will. People have said, oh, well, the first one also concerns bankruptcy. I say, okay, if that's the case, then be explicit about bankruptcy. It's not an argument for using the first one. It's an argument for saying whatever is on your mind regarding bankruptcy. Okay, this sort of definition, authorization, or I'd probably say permit now, but okay, let's say it's permit. Permit means, and then if it's a defined term, you see lots of words. Basically, people are putting every word that can be on a permit. Anything a government agency can call a permit. They'll say permit means consent, authorization, license, approval, certificate, blah, 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 blah. And it's kind of annoying. Here's an alternative. You could say authorization means any authorization, however referred to. In other words, we don't care what the piece of paper is called. If conceptually it's a permit, then it's a permit for purposes of the contract. It's just kind of simpler. Is there risk involved? Well, there's risk involved here, which is, hey, we've listed 19 things, and then, oh, here's a new piece of paper, and it has a different word on it. Is that a permit? as this in this definition, after a while, a court may say, "What were you going to? Why are you including all those examples if you also want us to include things that aren't in your long list?" So there's risks listing all those examples. If you just use this, the risk is just getting into a discussion, is this conceptually a permit? I'm not saying you should use this, it's just that it's another approach that I found myself using recently, not for the word permit or authorization, but with something else. Needless elaboration is where you say something like, I don't like fish, whether fresh or salt water. And you say, you don't like fish, I got the idea. You don't have to tell us all the different kinds of fish you don't like. So any government body, whether state, federal, or local, just ask yourself, do I need to say all the different kinds of fish I don't like? Do I need to say exactly all the different kinds of government bodies there are? I think the simplest thing would be not to, unless you have some good reason to include it. And just, we talked about examples already. Force majeure. Force majeure provisions, do you use them? Force majeure, oh, of course you do. Railroad projects, oil and gas projects, yes. Do you agree that, you see, force majeure means landslides, plague, earthquake, rioting, and so on, and you have a long list. It gets kind of silly. I asked someone to suggest the silliest thing they've seen in a force majeure provision. Someone said, space debris. Yes, I'm sorry we couldn't build the refinery because the Chinese space station landed on us. But then at a seminar, someone said, we're in the satellite business. Space debris is force majeure. I said, I believe that. But I saw something even sillier on, of course, where else? Twitter. A few days ago, someone said, look what I saw in today's contract. It was force majeure, and one of the force majeure provisions elements was intergalactic struggles. And someone doing a little joke, obviously. But so anyway, I don't list the examples simply because the question isn't whether it's in the list. Its question is whether it's whatever it is matters enough. For example, you can have earthquake in the list. Oh, there's an earthquake, and the teacups on the shelf rattle. And that's it. It was an earthquake, but it's not force majeure. So you can look on I have on my blog, search for force majeure. I have quite a lot of items about force majeure, including my force majeure language. And it doesn't have that list of locusts or whatever, tsunami. It just says anything that is beyond the control of the parties that interferes in some way.
It's better to revert to a standard where you could define whether it's force majeure or not.
Well, essentially what I make is I say here it's just something that people can't control, and if I want to carve things out, like labor strikes, okay, we can carve things out. So it's an approach to consider.
Does we need to add something that, the result of it? Even if it's something that people cannot control, but it does not result in anything.
Okay, well, sure, then, hey, check out the blog posts, because there are plenty of issues to get into in force majeure. I just wanted to mention that examples generally can get annoying and aren't necessary, usually. Rhetorical emphasis is where you don't just say something, you also wag your finger or bang your fist on the table. So, debt securities of whatsoever nature. Debt securities by itself means all debt securities. Of whatsoever nature doesn't do anything. Same with will be wholly and fully responsible. Just will be responsible. Will be under no circumstances. Instead of under no circumstances, just will not be liable. Contract language shouldn't have a voice, but it can have a really annoying voice if you bang your fist on the table all the time. Don't go crazy with initial capitals. The modern style is, I use the Chicago Manual of Style. It says, lowercase letters there, cross-references, section, small s, board of directors, small b, small d, president of Acme, small p. Just the modern tendency is lowercase letters for things like that. Numbers. Are you words and digits people? Words and digits for numbers? 10, T-E-N, parens, 10. Yes?
Depends on the number.
Excuse me?
I think it depends on the number. There's a rule
Well,
whether or not you write it.
well, of course, the question I ask, what rule is this? Where is this rule? Show me the rule. But yes, so the idea is that digits are easy to read, but you can make mistakes with digits. There was a case in New York from the 80s where someone forgot 3 zeros from a mortgage, and the judge said, congratulations, your mortgage is for $93,000, not $93 million. So people use words as well. And if there's an inconsistency, the words will govern. But the problem is, okay, you have mistakes that can happen with digits, but when you're trying to address that by doing words and digits, you are saying things twice. And one of the rules I mentioned earlier is don't say the same thing twice, because you're adding unnecessary words and it gets annoying having stuff like this in contracts endlessly. Acme may appoint one director, O-N-E, parens, one. It's just after a point you say, enough. And furthermore, the problem is that when you say things twice, as I mentioned before, you raise the possibility of inconsistency. The words and the digits don't match. And that creates a problem. The court will say the words govern, but actually it's more likely that the digits reflect the deal, because people read the digits more easily. So you're just asking for trouble when you're doing it, saying the same thing twice.
Doesn't it minimize the risk? I mean, I tend to make mistake with the digit more than words. So
yes.
Minimizing the risk.
Yes, one makes more mistakes with digits, but also you read the digits more easily than the words. So people tend to, for example, if you make last-minute changes, people can change the digits and forget to change the words. So inconsistency happens. You see quite a lot of examples of it. So I think it's asking for trouble. So I recommend that you use words 1 through 10, digits 11 up, and to avoid problems with digits, proofread. There is no magic solution. Proofread your numbers. I used to say that for the big number in a contract, like the amount outstanding under a promissory note, it's one number. If you want to do the words and digits, go ahead. That was until a couple of years ago when I saw a court opinion from Texas where the words number was lower than the digits. And the lender said, please let us show you that we lent this guy the digits amount. And the court said, no, the words. And the bigger the number, the more likely it is you pay attention only to the digits, because the digits is going to be that. The words is going to be like that. 16,423,000. It's long, and you just say, I see the digits, and I kind of don't pay attention to the words, and inconsistency happens. So even if it's a big number, I'd say just use the digits and proofread them. Arbitration clauses. To reflect that we're at the Saudi Center for Commercial Arbitration, here are some simple thoughts on drafting arbitration clauses. It's okay. Well, first you're going to choose which whether you want litigation or arbitration or something more custom made. If you're in an international context, arbitration is usually going to be the sensible option. And beyond that, you're going to have the, you decide, all right, are we going to make this up ourselves, or are we going to we rely on an institution to help us manage this? Ad hoc makes sense, perhaps, if you have companies that are very experienced with arbitration, and it's a kind of distinctive kind of project, a particularly large project. Okay, there are challenges, but there can also be benefits. But I suggest for the large majority of contracts, institutional arbitration makes sense. And from my perspective, the choice is a simple one. For other contract provisions, I say, okay, notices provision or governing law, there's all sorts of things we can discuss. But for arbitration provisions, the safest thing is simply you choose the institution, you use the institution's rules, and you use the institution's model clause. Because it's when people try to get creative that they make trouble for themselves. I've had occasion to discuss how, there are, I can make recommendations, and I have made recommendations to some of the institutions that, hey, you could make little adjustments here or there. But what those provisions say makes sense in terms of setting the scene for an arbitration. You can, in terms of defining the scope, well, one area where people can get into trouble is when they're trying to somehow be creative as to what is subject to arbitration, what isn't, and you can get into all sorts of debate about phrases like arising out of and relating to, and it can get confusing. So there's one area where being creative can create problems for yourself. In terms of place of arbitration, there are different considerations as to where you choose. You're either going to choose some place where if the project is in Saudi Arabia, then Saudi Arabia can well be a proper choice. In other contexts, people choose to go in somewhere entirely different. But whatever you do, it makes sense to choose a place that is where the country is a jurisdiction to the New York Convention, which would allow you to enforce an arbitration award.
Isn't it enough to refer to the institution arbitration rule, because they're going to cover up all those issues, and I think it's going to make the arbitration provision too long if you incorporate all the.
No. Generally, if it's a matter of just making sure for yourself that it is covered, that the place is a party to the convention, and there are very few countries that aren't party, so it's an easy choice to make. The obvious choice, you'd have to say, we're going to do arbitration in Burma or somewhere, Myanmar, or you'd have to make some strange choice for that to be a problem. Even number of arbitrators, you might think that's a safe thing to say, let's make it 3. Well, you might want to instead just rely on, for instance, the SCCA rules, where the rules specify, how the choice is made for number of arbitrators, because if you just say 3, and then ultimately you decide, you know what, we think that's a waste of money, but the other side is happy with 3, well, you're stuck with 3. So again, be open-minded as to the choice of arbitrators. In terms of the wording of arbitration provisions, I made a point of, I've explored that in a blog post perhaps 3 months ago. I looked in one of the model provisions, there's a sentence, "There shall be 3 arbitrators," as just an example of how you express that. And in another model provision, it was expressed differently. I was doing a lot of seminars then, so I put a blog post up saying, "Dear readers, here are these 2 sample provisions from model clauses that address the same issue. I don't think they have the right category of contract language. What do you think?" And then about 30 readers all said, "It's language of policy, it's this, that, and the other," making all sorts of suggestions. I came back later and said, yes, it is in fact language of policy. That just, the fact that the institutions didn't phrase it ideally is irrelevant. I just used it as an interesting exercise to show that categories of contract language is an interesting issue that can make you think in a lot of different contexts. It also makes sense to specify the language of arbitration. And there are different considerations that apply. But in terms of other things you can apply, like allocating costs, if you get adventurous, you can create problems. For example, you might say, okay, the prevailing party is the one who doesn't have to pay any costs. Then you get into an interesting discussion of what does it mean to be the winner? Because there can be different kinds of remedies and partial remedies, and pretty soon you're having, hey, let's have a whole separate dispute resolution mechanism to figure out what prevailing party means. So again, getting creative can be asking for trouble. Unless you feel you have particular needs, it's best to go with the model clause and the related rules. Okay. So, today you've had an introduction to a more modern approach to contract language compared with the traditional. Now the question is, all right, what do we do? There are 2 ways of looking at this. From the perspective of those who work with contracts is the first way. In other words, you guys. One thing to consider is, are you drafting or reviewing? If you're reviewing a contract, it's probably not the time to say, let's imagine you're a fan of this approach to doing things. This is the way contracts should be. Well, you don't want to get a draft from the other side and say, well, this agreement, small a, or the traditional recital of consideration, it's gone. What's all this shall stuff? Get rid of it. Indemnify and hold harmless? No. Or rather, represents and warrants? No. If you use the opportunity to give the other side drafting lessons, they might not appreciate it. In fact, they might get seriously annoyed. It's your job to focus on what can create possible confusion and to address things that you don't think reflects the deal appropriately. And limit it at that. You're not trying to make it into a thing of beauty. But there's plenty of stuff we've discussed that would fall within the scope of a legitimate review. For example, this is expressed as an obligation. Really, it's a condition. Let's express it as a condition. and indemnify and hold harmless. Do we really want to join the list of people who have litigated the meaning of indemnify and hold harmless? Let's say what the deal is for indemnification. Acme shall indemnify Widgetco against what? Because it's your job as reviewer to make sure it reflects the deal rather than mystery phrases. And this sentence exhibits syntactic ambiguity. Let's switch the order of these provisions to eliminate that confusion. So there's plenty that we've discussed today that you can use to comment on the other side's draft without annoying them unnecessarily. Who's your audience? Well, that's mainly an issue I encounter at law firms. Junior lawyers say, what are the partners going to say about this? But I think the approach is the same. If you are drafting for someone higher up the ladder, perhaps you find you get a sense of what they expect. If they're open to ideas, you say, attended this interesting seminar, have this handsome maroon book with interesting ideas. You want to discuss them. If they're interested in discussing, that's just great. You can say, and I'll get Adams on the phone, and we'll talk about it. It'll be great. That's fine. If they say, no, I'm good, whereas is good, hold harmless is fine. You say, okay, fine, I'm going to give you what you expect. But you can say, all right, I'm giving you whereas, but let's consider this issue that can create problems. You can pick your battles, like you're reviewing. You say, okay, here are some things we really should discuss. All right, you're the drafter. You have authority over your own drafting. You might say, everything I draft is now going to be a thing of modern contract drafting beauty. But you might have to clone yourself a few times over, because fixing traditional contract language takes time. And it's if you have a busy day doing your regular work, it might be difficult to say, can you give me 3 weeks to fix this contract? I've encountered that myself. I recently did an in-house seminar with a U.S. technology company. Some of the people had attended a seminar a couple of years earlier. So they gave me some of their templates as part of the process, and I used examples, and I said I don't see any sign in your templates that any of you attended my seminars. These are just traditional templates. And they said, yeah, well, we're busy. It's hard to get to that sort of work. So I suggest you approach the task incrementally. Focus on those provisions you use most often, so you'll get a quicker return on the time invested. Now, how about the idea, of handling pushback? That's where you send out what you think is a modern, clear draft, and the other side sends it back, noting things like, this agreement small a, are you crazy? Where's represents and warrants, and where have the shalls gone, and so on. And people on your side of the table say, do these things affect the deal? And you say, no, not really. So you find yourself putting back in stuff you want to take out. I wouldn't want to exaggerate the risk of that happening. For one thing, my book has sold tens of thousands of copies, so it's safe to say that the contracts community has accepted it as a safe work. And furthermore, I got an email from a reader a few months ago. They said, I use your guidelines to draft my contracts, and no one congratulates me. No one pats me on the back saying, what a great job, what a clear contract. I said, oh, I'm sorry. No, I said, be glad for that. You don't want to attract attention. Hey, look at this crazy new contract language. What I do, apart from, hey, this agreement small a, or states instead of represents and warrants, what I recommend doesn't attract attention. It's just clearer. But we're in a precedent-driven and very conservative profession. So you can expect people, there are going to be some people who just say, I like my traditional stuff. Where is it? I'm going to put it back in. I suggest that the best way to handle that is to let people know in advance what you're trying to do. In Appendix 2 of the book is something that I've put in the introduction of the 4th edition. It's a fantasy email cover note that says, here's our draft. It complies with the guidelines and a manual style for contract drafting. Please don't waste your time and ours by putting traditional stuff back in just because it's what you're used to. We have good reasons for doing it the way we've done it. So it tries to say that politely. People tend to attack the unknown. If you let them know what you're trying to do, it'll increase the chance of avoiding having them be annoying. So that's from the perspective of people who work with contracts. Now, all that's fine for the individual, but training individuals to be informed consumers of contract language isn't necessarily going to help the organization, because you're still going to have a bunch of people, different backgrounds, different training, different ideas, different experience they've picked up along the way. If you want a consistent, efficient contract process, you're going to have to handle some parts of it in a centralized kind of way. The first step is to adopt a style guide for contract language. To tell the organization, here are the rules for our contract language. Because otherwise people are just going to do whatever their experience tells them to do, and it'll be all inconsistent. Now, I used to think that my book would be a style guide. Yeah, it sort of is, but not for everyone in an organization, because the 4th edition, 600 pages. You can't give a 600-page book to everyone in your contracts process and say, here, do this. Figure it out. In 2015, Adobe Systems, the U.S. technology company, produced the Adobe Systems Legal Department Style Guide. I think the most important part of that is that it's 30 pages. The most important part is that it exists at all. It's a sign that the idea of a style guide is catching on. Of course, in my usual way, I went on my blog and wrote about all the problems with the Adobe Systems Style Guide. But again, the fact that it exists is the main thing. That's why, the idea of having hundreds of companies each producing their own style guide doesn't make sense. What makes sense is having some individual or organization with credentials produce a style guide that is used generally. So that's why next year I'm publishing with the American Bar Association a shorter version of my book. It'll be of a manual style for contract drafting. It'll be maybe 100 pages or something. I don't know. I'll find out soon enough. But it'll focus on what you should do. Here, do this, don't do these things, with a little bit of explication and references to the big book, making everything more accessible and with little warning notes, just so that you give everyone a basic idea of what kind of language you're looking for. It'll be called Drafting Clearer Contracts. What an original phrase. Drafting Clearer Contracts, a concise style guide for organizations. And we'll see whether organizations find that helpful. I'll be working with my clients and others in the US and globally just to make sure that what it contains is helpful for international organizations. You then train your personnel to draft and review consistent with the style guide. In sessions like this, you redraft your templates, because you can train people until you're blue in the face, but people are going to draft contracts by copying. And if you don't give them something good to copy, they're just going to copy traditional language. So you have to redo your templates. All that sounds like a lot of work, but if you do approach it sensibly, it isn't. I had a seminar client of mine recently say, inspired by the seminar you gave us, we redid one of our contracts. It only took us 18 months. I thought, that's about 15 months more than it should have taken. I don't care what kind of contract it is. So the one thing to avoid is drafting by committee, where you have people sitting around a room just kind of fighting to have their favorite contract language in the contract. All that is a mess. You enlist, instead, contract drafting specialists. I wrote an article on LinkedIn about contract drafting specialists. I had to say it, although I sounded kind of stupid saying it, I had to say, I'm the only contract drafting specialist I know of. Maybe there are others out there. I don't know them. Maybe just by saying that, I'll encourage others to become contract drafting specialists. In fact, I have fantasies about creating law school course to create contract drafting specialists. We'll see about that. The main challenge isn't the work to be done, it is inertia. People don't like change. It's not just a law thing. It's I've written about inertia in restaurants, inertia in sports, inertia in medicine. People who create the contracts don't like having you tell them that their contracts are less than perfect. Lawyers who have 20 years of experience don't like your telling them, we want you to express obligations like this. They say, no, part of the deal of being a lawyer is you get to decide how to do stuff. So there's just resistance to the idea of change. But it's up to any organization to decide what they're more afraid of. Are they afraid of change, or are they more afraid of wasting lots of money, lots of time, assuming unnecessary risk, and hurting their competitiveness? And how an organization answers that question depends on who's making the decisions, what the business is like, what industry they're in. There are different factors. And who knows how any organization will answer that. Contract drafting is hard. With with the greater the analysis I offer, the more analysis I offer, the more I say this is not easy. With my article last week, it's on a completely new subject. And I said, great, this is just yet more complexity to give to people. That's why I would like to see, even though, hey, I love contract drafting, but I think it would be a good idea to take the keyboard away from most people and use automation to have people create contracts by answering an online questionnaire. A lot of questions, explanation, you can click on links to find more. You go through the questionnaire, and when you're done, the system gives you the customized draft. And I have a confidentiality agreement that is customized like crazy. It's for use in employment, in M&A, in commercial context. It'll ask you, it can ask you 80 questions, and it'll create something highly customized. I keep looking for ways to create something like that. I'm in constant discussions. I'm now in discussions again with another potential partner, because this would be a big challenge. But the idea is just to make a lot of companies are using automated contract drafting, but it doesn't make sense to have hundreds of companies each creating their own automated master services agreement or whatever it is. Instead, it makes sense to have one reputable publisher with credentials say, here's something customized, create your own version and then do what you want with it, and you'll save hundreds of hours and you'll get a much better product. So I see that as the future I'd like for contract drafting, because reinventing the wheel is not a good use of time for people who work with contracts. You can better spend your time on negotiating, helping devise strategy, doing research, all sorts of other things, rather than constantly reinventing a wobbly wheel. So we'll see where that goes. In particular, I'd have thought that it might be of interest for Saudi lawyers working on straightforward commercial transactions to have available to them a library of automated templates that offers Saudi governing law as one of the choices. So immediately they're customized in ways that are necessary for the local jurisdiction, and you go through and you answer the questions and you get a draft that you can then customize further. We'll see where that gets to. So that ends my part of this. We have 5 minutes. If anyone has any questions, observations, anything come to mind, anything, certainly.
First of all, I'd like to thank you for this workshop.
My pleasure.
It was an eye-opener.
And
secondly, from the date on which you started with this new approach.
Yes.
To what extent, because you did mention that, there's going to be pushbacks, there's going to be...
Yes.
I mean, to what extent do you think that your approach
Progress?
is being taken?
Okay. There are a couple of ways of looking at it. In a general way, the guy who writes the book sets the rules. I think of it in terms of spelling in English. Before, the first dictionaries was all over the place. But once dictionaries came along, very quickly spelling became more standard. So I don't wish to be too ambitious about it, but my book is the only reference work of its kind in a field in a complicated field. So the book is selling very well. The ABA loves the book, and we're going to keep the fourth edition. The fourth edition will do very well too. So the word is getting out, and it is something that people consult, and just the fact that a recommendation is in the book automatically gives it a certain credibility. It's something that people can point to, and I hear from all sorts of readers that in negotiations they say, look at section whatever. They can point to something instead of just making it, hey, I once heard someone said, or whatever, just invoking some random thought. So having a book helps direct usages in that way, towards that direction. As a bit of a joke, I did a little test to see the extent to which people are reading my stuff, because my concluding clause is distinctive. The parties are signing this agreement on the date stated in the introductory clause. I mean, that's mine. So I looked at the SEC's Edgar system, where public companies file their contracts, their millions of contracts, and I looked year by year for the past, I did this 3 or 4 years ago. I looked for 10 years, and it was 0, 0, 0. Now I was starting to get worried. 0, and then 5 contracts, 10 contracts, 22 contracts, 10 contracts, and it was sort of so. It's trivial because for the the 25 contracts that use my closing clause in 1 year, there were 596 that used witnesseth. So I'm not suggesting that that my approach is going to take over the world, but it's making progress. And furthermore, I don't have to take over the world because all that matters, it's not like contract usages are subject to a popular vote. It's not like I'm running in some sort of election. All that is required for you to follow my recommendations is for you to think that they make sense, for you to convince people on your side of the table, and for you to convince people on the other side of the table. Do that, and it's done. So it's not like it's some big challenge. So you don't. And as we discussed earlier, I'm not judges do mention. That's another thing. I think about a dozen U.S. courts have cited my book in court opinions, and the article last week was in a magazine for judges. So I hope they'll cite it even more. But don't expect to have courts say Adams is right, because the whole point of my recommendations is you don't end up in front of a court. So the main thing is if it makes sense to you and it makes sense to the people on the other side of the table, that's all that matters.